Okay, well, good morning, everybody. Thank you very much for joining us today and making time in your busy schedules to attend our third annual Public Interest Disclosure Conference. I'm Rachel Warren, the manager of the BC Ombudsperson's Public Authority Consultation and Training team, and I will be moderating our virtual time together from our office, which is located here in Victoria on the land of Lekwungen speaking peoples, the Esquimalt and Songhees First Nations. And we humbly thank them and their ancestors for their past and present stewardship of these lands and waters. We have a large group, as I said, joining us from all around Canada, actually. And while this is a BC-centric event, we have people from coast to coast to coast with almost every province and territory represented. And we're excited to be hosting this for the third time, virtually again this year. And we really, truly thank you for your interest in this conference. We're confident you'll be taking away some important information about public interest disclosure to help you in your work. So I'd like to start our morning together by first introducing our ombudsperson, Jay Chalk, who will be saying some remarks and opening the session for us. And I'll pass things over to Jay. Thanks.
Thank you, Rachel. Good morning, everybody. I'd like to personally welcome you all as well to today's conference. I'm joining you from our office, which sits on the beautiful lands of the Lekwungen-speaking peoples, the Esquimalt and Songhees First Nations. As Rachel said, this is the third public interest disclosure conference that my office has hosted. Seems hard to believe that in late 2019, just 2 years ago, we were all gathered in one room at the Delta Hotel, eating sandwiches and chatting in person at our first event, back in what we all now call the before times. But here we are for the third time and for a second year doing this virtually. It's so wonderful that we have over 160 registered to be here today. We have designated officers from public bodies already covered by the Act, mostly from British Columbia government ministries, who have the important role of giving advice and receiving disclosures, and many of those designated officers already have firsthand experience doing so. And we have other officials from government ministries as well. Also attending, we have many staff of public bodies that are to be covered by the Act over the next 3 years, and we're going to hear more about that later. Those people are here because they want to learn more about their new and upcoming responsibilities. We have colleagues from other British Columbia independent offices of the legislature, from public sector unions and employee associations, Indigenous organizations, and folks from civil society organizations who have a keen interest in public sector integrity and accountability. And a warm welcome to those joining us from outside British Columbia, including public interest disclosure colleagues from across Canada, from Quebec, Ontario, Alberta, Manitoba, Nova Scotia, and the Yukon. I know you're all very busy in your work lives, and that the time you are taking with us for the next few hours is a precious resource. So we're endeavoring to make the most of that time. The fact that you're devoting that time speaks to your strong commitment in maintaining a high degree of integrity in public service. And for that, I'm very grateful. So many thanks for coming here today. I look forward to getting a lot out of this morning, and I'm sure you do as well. Those of you who joined us at last year's Public Interest Disclosure Conference will remember that we focused on the theme of how to encourage a speak up culture in public sector organizations. We invited workplace expert Craig Dowden to join us to talk about how to encourage a workplace culture where people feel safe to raise concerns and trust that those concerns will be taken seriously. We were reminded that a speak up culture can act as a pressure valve, preventing minor issues from escalating and becoming major problems down the road. As Craig pointed out, while it may seem like a paradox, it's healthy for organizations to encourage and foster employees to feel good about raising concerns about things that they see in their organization that are not right. This year, we'll be looking to the more distant past to learn lessons of how a speak up culture, or lack of it, can potentially influence the course of history. We'll learn more about the story of a physician who was employed by a federal government department whose voice was silenced when he raised concerns about the conditions in residential schools in Canada a century ago. And we'll have the opportunity to reflect on the question of what could have been different if his concerns were taken seriously by the senior public officials of the day. Before we jump into today's program, though, I just want to share a little bit of information about some of the trends that we're seeing in the public interest disclosure work at our office. It's still early days, but there are a few things that we're seeing so far. The first learning is that employees have usually tried to raise their concerns internally in one or more ways before making a disclosure to us, and don't feel satisfied with how their disclosure has been handled. That fact is both frustrating and encouraging. Frustrating in that one hopes that those concerns would have been addressed when they first arose, but encouraging in that we see that public employees are not giving up. They're determined to report their concern a second time, this time to us. And sometimes that's because they don't believe their concern was listened to the first time. Other times because they don't know what happened with the concerns that they raised. So what to make of a fact that a number of people who come to us feel they either weren't listened to internally or they're not adequately informed of actions that were taken in relation to the concern they raised. Leaders need to think of ways to communicate within their organizations, or at the very least to those employees who raised concerns, that action is being taken, even if they can't give details about what an investigation yielded about another employee for legitimate privacy reasons. And it's important to recall what Craig Dowden reported, that most public servants want to report their concerns internally rather than to an external body such as my office. As Craig explained, they want to believe they work for an employer who cares as much about doing the right thing as they do. So I believe it's also telling leaders of organizations to ensure internal processes for receiving disclosures are strong and responsive. While the motivation of disclosures may differ, they share a common goal of wanting their organizations to be better. That goal is encouraging as it speaks to an aspirational push to keep the integrity of public services strong. It's notable that about half the disclosures coming to our office pertain to workplace bullying, harassment, or toxic workplaces. This is, I know, discouraging to hear. It tells us there's more work to do ahead in creating a workplace environment where people feel welcome, secure, and safe. This work to cultivate and nurture a strong and positive workplace culture takes time and ongoing and dedicated commitment. I know it's something that all organizational leaders want for their organization, but it appears that it's a work in progress in some places. We're learning that the range of issues that people perceive as wrongdoing is incredibly diverse. And each matter that comes to us raises new issues and brand new questions. Questions like, when might it be best for a public body or our office to refer a matter to what is called under the Act a protection official, namely law enforcement, emergency management BC, or the public health officer? What are the subtle nuances around the eligibility of who can make a disclosure under the Act? And when should we exercise discretion not to investigate, such as when the allegations pertain to a public policy decision or because of the amount of time that has passed? People are using the law and clearly need and appreciate an independent avenue to share their allegations. Before the new law came into force, one big question for my office, and I know for government, was how many disclosures would start to come. And I can tell you there has been a steady flow of calls to our office. More or less, we received one disclosure a week for the first 16 months the Act was in force. And on top of that number, other inquiries and requests for advice. And one final learning I'd like to share is that we're seeing that public interest disclosure laws make a difference. It's still early days here in BC, so while we can't yet point to many public outcomes of investigations here, we just have to look at our ombuds and public interest disclosure commissioners across the country to see the difference that these investigations are making. For example, in Manitoba, public interest disclosure investigation by our ombuds colleagues in that province found serious breaches of policy and legislation that enabled the theft of public funds by a staff member of a public body. As a result of the investigation, new policies, tracking systems, and procedures were put in place to prevent that from happening again. In Alberta recently, an investigation by that province's Public Interest Disclosure Commissioner found a college president had grossly mismanaged senior level employees, public funds, and the delivery of public services, exhibiting a pattern of systemic bullying and harassment. The Public Interest Disclosure Commissioner made several recommendations to strengthen oversight of the position of president. The college welcomed the commissioner's report and indicated the investigation underscored the importance of a speak up culture. The Public Sector Integrity Commissioner of Canada conducted an investigation recently that found gross mismanagement occurred when the Correctional Service of Canada neglected to take adequate measures to address insubordination, harassment, and misconduct by several correctional officers in a penitentiary. There was also a finding that CSC hadn't taken adequate steps to prevent a substantial and specific danger to the life and health and safety of a staff member, and that danger had been deliberately created by correctional staff. While the Correctional Service of Canada disagreed that serious wrongdoing had occurred, they did acknowledge that recommendations made following the Public Sector Integrity Commissioner's investigation were constructive in assisting with improving workplace health and safety and committed to implementing them. These concerns, I am sure, are encouraging for all of us. Voices are heard, change is made, and public administration is made stronger. It's a win-win-win. And even though, given it's still early days, I haven't yet publicly reported about the investigation outcomes of my office under the new law, I can say that even where we have not found wrongdoing, we have made recommendations to improve government policies and practices. Because the new law contemplates that even where conduct is not so serious as to constitute wrongdoing, that does not mean that nothing wrong happened or that improvements cannot be made. And so recommendations may be made in such circumstances. Looking ahead, as most of you here know, the law will cover an increasing number of public services. Right now, the law only applies to current and former employees of the BC Public Service and staff and former staff of independent offices. But in July, the Attorney General laid out a schedule to expand coverage of the Act over the next 3 years. Beginning in April 2022, just 4 months from now, tribunals and a number of agencies and other bodies in the province will be covered by the Act. And beginning next December, Crown corporations will be covered. Starting in June 2023, health authorities will be covered, and later that year, school boards will join. University, colleges, and more agency boards and commissions will be covered the following year. And you'll hear more about this rollout later this morning. I want to recognize the staff of the policy staff at the Ministry of the Attorney General for their diligent work on this rollout that will expand the coverage of the Act from the current coverage of about 35,000 public servants to over 300,000 current public servants by the end of 2024. Staff at our office have held meetings with many of the April 2022 wave of public bodies coming under the Act, including many of you here, to highlight that we're here to help with implementing the roles and responsibilities under the new law. For them and for all the public bodies falling under the Act over the next 3 years, we have a range of support resources available, such as planning timelines for chief executives, tip sheets for designated officers and supervisors, sample internal procedures for organizations that they can adapt and adopt. And coming this month, 2 new resources, a brand new e-learning course that's a great overview of why the new law is needed and how it works, and a webinar targeted at public sector supervisors who have a key role under the Act, helping them with meeting their responsibilities under the Act. These are all available on our website, and we'll be sending a follow-up email to all of you with links to the resources and a heads up when those 2 new courses are posted. If there are other resources that you might find useful, please don't hesitate to contact us, as we're continually adding more tools to our implementation kit. From our conversations with staff and public bodies, we know that people have a lot of questions, and learning how to implement the new law is not straightforward. And so we're here to help. Our goal is that by the time the wider provincial public sector is fully covered by the new law, all public bodies will have the tools and resources that they need to fulfill both the spirit and intent of this important legislation. This conference is an important element of that support. It's really the only time when we all come together to share and learn from one another's experiences. And I know I've learned a tremendous amount from our 2 previous gatherings, and I hope those of you who have attended these have as well. And with that, I'm going to turn it back to Rachel, and I just want to wish everybody a terrific morning, and I look forward to a great learning a great amount from today. And thank you again for your participation. Rachel?
I think at this point, what I'd like to do is turn things over to Carly Junick, who's the manager of our public, public interest disclosure team.
Welcome everybody here today, and particularly the new public bodies that are coming under PIDA in the future. So we actually have quite a few of you today. Some of you have already met with either myself or John Greshner, who is the Deputy Ombudsperson. Those bodies coming under PIDA in April 2022, but I know we also have representatives of the organizations coming in December 2022, as well as a few the following year. And I know Jay spoke briefly to that as well. I just wanted to highlight again, that's the schedule that government has announced for when the bodies will be coming under PIDA. Right now, it's just ministries and offices of the legislature that fall under our Public Interest Disclosure Act, but we've been really busy getting ready for the next phases. Like I said, John and myself have been meeting with the April 2022 group of folks. And I just wanted to let everybody else know who's coming under PIDA in the future to expect the same. So for the December 2022 group, you can actually expect a letter from the Ombudsperson shortly with an invitation to set up a meeting with either myself or John. And the purpose of those meetings, just a quick half-hour meeting, usually with the Chief Executive or anyone else who's involved in the implementation of PIDA for your organization. And the purpose is to just give you a quick overview, if needed, discuss any questions you might have, get a bit more information about your organization so that we can better assist you in the rollout. We've developed a whole bunch of resources. We also have people who are available to assist with consultation. And so, you know, for smaller organizations or even large organizations, we have sample procedures. So every organization is required to have their own procedures. We actually have a sample set of procedures that organizations can just adopt or adapt. But some organizations actually might already have quite developed integrity programs or internal whistleblowing programs and need to reconcile what you have with PIDA to make it PIDA compliant and make them speak to each other and work together. So our office is also available to do some of that consultation work with you while you develop your procedures under PIDA. So Rachel will let you know a little bit more about the resources available on our website at the end, but that's what to expect from us going forward. Last thing, I just wanted to, Rachel, if you're just also able to quickly put up that slide on the different roles under PIDA. I just wanted to acknowledge everybody that's here today and the different roles that people have. So again, I know we have people who are here today who don't have a role under PIDA, but some of you do or will in the future. And so just wanted to highlight that as well. When we go later on into the workshop sessions, most of the sessions are a mix of people. And so it'll be really interesting to hear from some people who've been doing some of those roles already, as well as others who are coming under. So the first is the chief executives, and that's the leader of the organization who has responsibilities for ensuring that procedures are in place, designated officers are designated, and that employees know how to access PIDA. The second is designated officers. And designated officers, there can actually be more than one in an organization. PIDA allows for that. So they provide advice. They're sort of the gateway to PIDA for that organization. And You can designate more than one so that you have some designated officers that, or one that maybe just receives disclosures and then somebody else perhaps with the expertise who does the investigations. So that's an option as well. The next sort of level of roles and responsibilities under PIDA is supervisors, and that's anybody with a supervisory role. And those folks will also be employees, but they have a main responsibility for providing advice to their own staff. And they can also receive disclosures. They aren't involved in assessing them. They then forward disclosures, which is a report of wrongdoing, to the designated officers who then deal with those. Lastly, we will have lots of people in the virtual room today who are employees under PIDA in one way, shape, or form. Even supervisors are. And those are the folks that are intended to be covered by PIDA. And so you're able to seek advice and disclose wrongdoing. You are intended to be protected from reprisal. And we'll talk more about that in the sessions. So I just wanted to acknowledge all of the roles and just make it really clear that we are here for anybody, not just through the implementation of PIDA. We'll be working with the chief executive and other leadership and designated officers in implementing PIDA. But even once it's enforced, if you have any questions at any time about your role or how it applies to you, please think of us as a resource and let us know how we can help.
I'd like to introduce our keynote speaker, Dr. Cindy Blackstock. A member of the Gitxsan First Nation, Dr. Blackstock is the Executive Director of the First Nations Child and Family Caring Society and professor at McGill University's School of Social Work. She has over 30 years of experience working in child welfare and Indigenous children's rights, and has published more than 75 articles on topics related to reconciliation, Indigenous theory, First Nations child welfare, and human rights. As you I'm sure will know, Dr. Blackstock is currently involved in major high-profile litigation on behalf of current and former Indigenous children in care against the Government of Canada. So we appreciate very much her fitting us into her incredibly busy schedule. Dr. Blackstock, it's wonderful to have you here joining us. Welcome.
Thank you. It's a great honor to be here. I'm joining you from unceded Algonquin territory here in Ottawa. And I really want to pay my respects to the territories that you joined from, and a particular word of appreciation, of support for all the people who have been impacted by the climate change crisis and the flooding, the fires, and everything else that's been going on in BC. So I want to talk to you today about kind of learning from the past, or in some ways not learning from the past when it comes to whistleblowers, and really how important they are, not only to the particular issue, but actually how when they fail to get heard, how it costs all of us in society. And so I want to talk to you a little bit about the children in the unmarked graves. In June of this year, of course, we found Chief Casimir from Kamloops in front of the Kamloops Indian Residential School, announcing that 215 sacred little children were buried in unmarked graves at that site. And that was just the beginning. We had then over 700 found in Cowessess and more. The numbers are now well into the thousands, and that will continue to sadly grow. And when that came to the fore, there was this kind of shock in the country, this emotional shock wave that hit in ways that had not really been present before, even though the survivors had told their truths about these children in the graves. And in fact, some of these survivors actually buried some of these children, so they knew they were there. But the public didn't grab it until they actually saw these little wooden stakes in the ground, marking where children would die, literally going to school. During that same week, the Canadian government was in court against this generation of First Nations kids in a case involving the Canadian government's inequitable provision of public services to First Nations kids. So you had two of these things happening at one time, and yet so often the dialogue about the unmarked graves was, this is a dark chapter in our history. But unfortunately, that's actually not true. I think that, first of all, we need to confront some of the myths of that that we tell ourselves. like people back then didn't know any better. The government mustn't have had the answers to deal with the problem. That there were different moral standards back then than we have now. And that surely things have progressed so that these kinds of harms are no longer with us. These are things that we all kind of tell ourselves as stories in this colonial dialogue, but they actually get in the way of us seeing contemporary human rights abuses. And I might add another one on top of that, and that is that the government would never do something like this again. After all, it said it was sorry, it must have learned something from it, it's not going to do it again. So the truth is that all of the evidence of the children dying was known to people of that time. It was considered to be appalling to people at that time. In fact, some even felt that what Canada was doing was criminal. There were solutions to stop some of those children from dying. We don't know the cause of death for all the children, but we know that many of those children would have lived had these solutions been implemented. We also know that there were people speaking up about it, but it was government retaliation that allowed for the continued unnecessary deaths of those children. And here I use the word choice by the government, not failure. It's something different. It's when you have all the information before you and you choose to not act on it, knowing that these are harms that are happening to people. That's different than failure. It's not a failure to deal with residential schools. It was a choice to really allow these kids to die. And I'm going to show you why I make that kind of statement. The other is that the injustices, many of these injustices that were known well over 100 years ago are still with us. And my key message is that human rights defenders in 2021 deserve the support and protection to really get reconciliation grounded, but to do more than that, to actually for the betterment of society. And there are so few protections for human rights defenders. So let's begin with a guy who actually knew what was going on. Whoops. Sorry. So this is the guy who knew better. And he wasn't just some guy off the street. This was the chief medical health officer of the Indian Department. He was born in Mount Pleasant, Ontario in 1853. He got his medical degree in 1886 and actually was considered to be one of the North America's biggest experts on public health. He was president of the American Public Health Association. So not just some backwater person, someone who is very well established in the public health community. He wrote Ontario's first health code, which was broadly replicated by other provinces. In fact, many of those provisions we all relied upon to kind of get us through the pandemic. Some of the standards around clean water, around infectious disease, they were given birth then. Of course, they've been refined since, but this health code was highly replicated. Now, Dr. Bryce's kind of ambition was that great timing for the testing of the fire department, but we're going to ignore it for now. But Dr. Bryce's ambition was to become Canada's chief medical health officer. And a stepping stone was to become the chief medical health officer of the Indian Department. This is in 1904. And at that time, it was well known that children were dying in these schools at a rate of an estimated 50% from Canada's own documents. That's why they sent him out to look at what the health of the kids in the schools. And what he found is that there was a death rate of about 25% per year. Imagine that in any local elementary school where a quarter of the children would die in that year just for going to school. And that number rose to 50% over 3 years. In one school for which there were complete records, for every 3 kids that walked in, only 1 would walk out alive. The death rates in the schools, even as late as the 1940s, you were more likely to die in residential school than you were as a soldier going off to the Second World War. That was how grave the risk was of being a child in one of these schools. Now, the key cause of death that Dr. Bryce was seeing was tuberculosis. And you may be saying to yourself, well, Tuberculosis was a thing back then, and a lot of people died from it. And you're right, but not at these rates, not nearly as close. And why was that? Well, Dr. Bryce noted that there was serious inequalities in the healthcare funding for Indian children compared to other children. So these kids were getting on the cheap healthcare. They were also poor health practices. They were putting sick kids in with healthy kids. There was poor ventilation in the buildings. The children were malnourished, so they're more susceptible to disease, overcrowding, you name it. All of these problems were there. The price tag to fixing these healthcare threats to these children was about $10,000 to $15,000 then, of about $100 million budget. So really a drop in the bucket even back then on a national budget. But Canada chose not to implement the reforms. And it wasn't just bureaucrats. We often hear about Duncan Campbell Scott, and we'll hear about him in a minute, the chief bureaucrat on the residential school file. But when Dr. Bryce was stonewalled by Duncan Campbell Scott, he actually writes to Prime Minister Laurier, pleading for him to help save these kids' lives as well. Well, all of this reporting gets leaked to the national media in 1907, and we're about to see a headline from just one of the papers, but this was covered nationally back then. And you'll judge for yourself about what the tenor of that particular paper is. He got retaliated against by Canada. When it appeared in the media, the Canadian government took immediate action. They cut his research funding on the statistics of children dying. Imagine how useful those would be now as we're trying to link who these children were in the unmarked graves. They also stopped him from doing any publications or presentations at academic conferences, and they denied him for positions for which he was eminently qualified. This was a very serious case of retaliation. They pushed him out of the public service, and they basically erased this guy from history. You would have found nothing about him until about 19 Royal Commission. Researcher John Malloy finds this story of Dr. Bryce resurfacing in the historical record. So he dies in a very modest grave in Beechwood Cemetery. So here's the headline that appeared in 1907. This is the Evening Citizen, now the Ottawa Citizen, for those of you who come to Ottawa, but headlines like this appeared in all the papers, including as far west as the Victoria Colonist, where a lot of you are from. And you can see here that this is a story that's picked up by the editors. So the editors of that time actually thought that this was pretty shocking, right? Business. Not only because we can tell that because they put it on, first of all, the front page, but for those of us who are old enough to know when newspapers were a serious form of news, the most important stories go above the fold on the newspaper, right? And this is above the fold. And you can see that it says, schools aid white plague, startling death rolls revealed amongst Indians, absolute inattention to the bare necessities of health. There were other newspaper headlines like the children are dying like flies. The readers of the paper, so we can see that the editors of the paper, the journalists of the day, did not think this was just business as usual from the standards of the time. They thought this was really quite shocking, and they were reporting on it. Now, some of the folks reading the papers were equally as shocked. In fact, many people were. One of the folks that read it is Samuel Hume Blake. For those of you who are lawyers on the call, you'll know Blake's law firm, which continues up until today, and this is one of its co-founders. And he was an esteemed lawyer, later a judge. And he says that in the Canada fails to obviate the preventable causes of death, it brings itself into unpleasant nearness with the charge of manslaughter. So this, you can see why the people back then thought this was not only immoral, but quite possibly very criminal. Now, what the problem was is that the headlines would have a burst of this kind of energy about the injustices happening, the dying of the children. But then the headlines would die and the public attention would as well. And then the government of Canada would choose to do business as usual. And that's exactly what they did. They would just wait the headlines out and continue doing what they're doing. And now there are some folks who say, well, you know, the Canadian government was just trying to do the right thing. And I'm about to challenge that assumption right now. The assumption is, you know, they were trying to educate these kids and civilize them. And maybe that wasn't a good idea given what we know now, but back then that was the way things happened. This often comes up in conversations of whether residential schools were genocide, i.e. what was the intent? No one intended for these kids to die. So this is the guy who says no to Dr. Bryce. And his name is Duncan Campbell Scott. He was hired by John A. Macdonald himself when Duncan Campbell Scott was 17 years old as a clerk in the department, but he rose quickly through the ranks. And by 1895, he actually requests a warrant to force children into the schools for the purposes of, quote, education, but also for the purposes of they are not properly cared for. When you look at the not properly cared for provisions, they really were the codification of this very deep level of systemic racism and discrimination as a parental deficit, plus this romanticized view of the preference of raising children in a Western world. So by 1904, he knows the kids are dying at 50% already. This is when he sends out Dr. Bryce's to do the work. And then when Bryce comes back and points to the fact that these kids actually would be alive if you only funded them on the same kind of level as other kids, and if you stop these bad health practices, they choose not to do it. Now, this is very important, and you can actually find a lot of the information in John Malloy's book, A National Crime, that tells the whole story of residential schools from the perspective of Canada's own documents. He chooses not to do it, knowing the children are dying, and he retaliates against Bryce. In 1910, so 3 years after Bryce's report comes on the National Citizen, he writes a letter to the Regional Director General in British Columbia. And he says, it's well known that all of these kids are dying in the schools at far higher levels than they would in their villages. But this alone does not justify a change in the policy of this department, which is geared towards the final solution of the Indian problem. And that final solution was, of course, if these children died, it was an easier piece to kind of get the land and everything else that would then become available to Canada. So these kids were literally expendable, according to Duncan Campbell Scott. And Laurier, remember, did not intervene on behalf of these children. Often when we tell the story of residential schools, we focus on John A. Macdonald, and he, of course, did launch them. And he was a serious racist. Even for his time, people would speak out against him. But Laurier does not have clean hands in this business. In fact, after Dr. Bryce gets pushed out of the public service, and he publishes a pamphlet called A National Crime, showing all the correspondence of how he was trying to save these kids, Duncan Campbell Scott doubles down, and he makes attendance at these schools mandatory, not just via the warrant, but via legislation through the Indian Act, which of course sadly is still with us today. He, instead of getting punished for this though, he actually gets rewarded for his behavior, particularly by Canada. He's considered a loyal public servant. They have a big gathering for him when he retires. He even served as president of the Royal Society in 1922, same year that Bryce's National Crime is circulating around Ottawa. No mention in the Royal Society minutes of the controversy of their president. He dies in Beechwood Cemetery, and Canada anoints him with a bunch of recognitions. One of them is that Parks Canada includes him on a list as a person of national significance. Now, I have no debate about this. Some of you know Duncan Campbell Scott in his off time wrote poetry, very racist poetry, but nonetheless he wrote it, and was known as a Confederate poet. So as of like a few weeks after Chief Casimir reveals these children in unmarked graves. If you were to go to Parks Canada website, you would see Duncan Campbell Scott listed there as a person of national significance. But the reason he was listed was because of his, quote, advocacy in education. That's in 2021. So the propaganda by the Canadian state continues in a way that it tells a narrative about residential schools in quite offensive ways. They've since taken down the advocacy in education, but he's still up there as a person of national significance. And in fact, if you go to the National Museum in Ottawa, you're going to find a picture of him, and in front of him, there's a clear case of sacred items from his Duncan Campbell Scott's personal collection, without any explanation of why that is so disgusting, or without any kind of clear explanation as to what efforts the museum has made, if any, to return these sacred items back to those communities. So 100 years, let's go ahead a decade, because we want to talk about these whistleblowers and how they affect us now. So exactly 100 years from Bryce's 1907 report, I find myself with the Assembly of First Nations filing a human rights complaint against the Government of Canada, saying that their inequitable provision of public services for First Nations kids amounts to racial discrimination. And this type of racial discrimination is resulting in more children being separated from their families than at the PIDA residential school. Serious harms to children when they're denied health, education, and other services. And indeed, in some cases, deaths of children. The case is filed, and what does Canada do? Well, within 30 days, it cuts all its funding for the AFN and the Caring Society for Child and Family Services. In fact, it cut all of our funding. We've not gotten any government funding since we filed the case. But then it started to go after the case on technical issues, on jurisdictional matters. It would take us until 2016 to actually be able to get a decision on the case because Canada fought it so hard. But we had testimony by Chief Robert Joseph, known to many of you, as a residential school survivor and esteemed leader, and also John Malloy, the historian who wrote A National Crime. And it struck the panel of how similar Canada's behavior was in 1907 to what it was doing to kids in then 2016. That the government was continuing to shortchange these children, even though its own records, its own documents, its own officials were saying kids were dying, kids were being separated from their families, and they were being hurt. You've all, and I want to make the point that when there were multiple solutions available here, when 2000, we came up with a document with Canada that identified the inequalities and provided remedies to fix them. It would have cost about an additional $109 million back then. But instead of doing it, they ignored it. Then we did another report. And no surprise, the gap had grown by then because they hadn't done anything. And they accepted the report and did nothing about it. That's why we had to file this complaint. But I want you to keep in mind Bryce's $15,000 figure. Had Canada remedied those inequalities back then, we would have never found ourselves in a courtroom 100 years after his case. So why was this case so important? Well, now we've got over 1 million services to kids under Jordan's principle that they otherwise would have been denied just because they're First Nations kids. We have literally hundreds of millions of dollars in prevention services for the first time in many cases going to families to try and keep them together since Canada was in Confederation. But we've also had to go to the tribunal to get non-compliance orders against Canada. We're now up at 20 non-compliance orders, actually 21 non-compliance orders. But we've also been to the federal court and federal court of appeal. The good news is the kids always win because the factual matrix is so strong that Canada's behavior is egregious. And we also now have the Parliamentary Budget Officer estimating that Canada's compensation to the victims that it discriminated against could be well north of $17 billion. So you take that $15,000 that the government wasn't going to spend in in 1907. And then the 109 million it could have spent in 2000 and chose not to. And now the cost for society is literally tons of, tens of billions of dollars. But more importantly, children have died, children have been hurt, children have been placed out, separated from their families in ways that no amount of money will ever recover. So there was another story that's not well known with the tribunal. And that is that during that time when they were trying to get things off on legal technicalities and were not succeeding, they turned to other tactics. They decided to engage in surveillance about me, because I was kind of the public face of the complaint. What you're looking at here are snippets from Canada's own documents that I obtained under a Privacy Act request in 2011. And they were on not only on my social media, but they were actually physically following me around. How do I know this? Because they have, for example, notes from a talk that I did in the middle of the desert of Australia, literally in the middle of the desert of Australia. They would also note when I was not at gatherings. So it wasn't that they were just writing when I was at places, they would be writing that I wasn't at places. When I looked at the matrix of who was doing this, it turned out to be 189 different federally funded federal officials. These are not CSIS agencies or RCMP. There was no warrant involved here. This is just public servants taking upon themselves to go spying, basically, on a human rights advocate, that being me. So, and you can see why they're doing it here. They're saying I'm making comments that could affect the litigation and showing that I have other motives for filing it, right? They also kind of note here that, yeah, no, this isn't so routine, what we're doing. This is the, what happened in this is that I got the documents, then went to the Privacy Commissioner, and it then went to the Canadian Human Rights Tribunal to adjudicate on the grounds of retaliation. And through that, Canada was then forced to disclose more records. And one of them was this form. This is how they get permission to go and follow you around as a member of the public without a warrant. It's literally a one-page form. It's filled out by the Department of Justice litigation person. They just ask if they can go onto your personal page. It's signed off by the supervisor. But here's the bad news, at least as of 2014. There was no official guideline on what constitutes official business. And once access is given to an official, they've got it until they're not employed anymore. There's no oversight of what that person is collecting and for what purpose. And indeed, in my situation, I actually have an exchange with a 12-year-old who is about Spirit Bear, who many of you know is our mascot, and we do books and stuff. They actually took that. They went behind the Facebook, the public identifier, to find out who that was, and then circulated that transaction without that child's consent or knowledge or their parents' consent to over a dozen people in the Department of Justice. And it was just a very innocent kind of thing. Thank you for teaching us about Spirit Bear, that kind of stuff. And they would also do that for any interactions I'd have with other members of the public or people in my family. So this is the kind of stuff that they were doing in my case, in addition to the funding cuts for the Caring Society. So the privacy officer found Canada's conduct to be unlawful. The Canadian Human Rights Tribunal found Canada's conduct to be unlawful, and they ordered Canada to pay me $20,000 in damages, which I then donated to children's causes because I wasn't interested in the money, but I was interested in trying to just safeguard other people against this kind of behavior. And it was investigated by 3 UN rapporteurs. Now, what did I learn about it? Well, when I got the documents, I was actually, quite frankly, just gobsmacked. I could not believe it. I don't even have a parking ticket, let alone a criminal record. And to figure out that the government, in this way, without a warrant, was following me around, and that these people were completely untrained in doing this. I frankly would rather have the RCMP following me around. At least they're trained and there's accountability mechanisms. This is a bunch of people sitting behind desks or going to conferences, or I don't know what they're doing, following me around for inappropriate purposes. It was quite scary because I had a teenager in my house at that time. So you wonder, what are they doing to other members of your household? But I think one of the key things that I realize is that you have to speak up. You will be afraid, but you have to speak up. You have to have the moral courage to stand in the winds of that discrimination and speak up in a way that really brings light to the cause. It's not easy to do it that way, but you have to focus on justice and not on retaliation. So even though I had all of these documents with all the identifiers of these public servants, I provided them to the media only on the condition that they would not identify those people publicly, because I did not want to violate their privacy while I stood up for my own privacy. The other thing is you need to get support, and I'm going to show you how one organization that was was very helpful to me. And you need to collect the evidence. So in my case, the Privacy Act was a way of getting those records. I suspected it was happening, but I didn't know it was happening until I got Canada's records through the Privacy Act. Then when I got the records, I provided them to the tribunal, to the media, and to different watchdogs. And in some ways, like I feel that's why Dr. Bryce and I, in some ways, are quite bonded. Here's a group that very few people know. It's called Tactical Tech, and it's actually for use by human rights defenders to engage in activism in ways that really try to safeguard you against retaliation by different groups. Might be corporations, might be drug cartels, might be governments in different ways. Their resources are free of charge, and they're available in 27 different languages. They're supported by credible groups like the Frontline Defenders, who I'm going to get to in a minute, Amnesty International, and others. So this isn't a dark space in the media. This is really meant to protect those persons who are speaking about human rights issues and putting themselves at significant risk in doing so. So Frontline Defenders is a fabulous organization. It's based out of Dublin, and their job is to protect human rights defenders. So they have a whole series of supports for persons who are speaking out, whistleblowers, who are experiencing or are likely to experience some form of retaliation. Those supports can include things like advice on how to handle it, who do you go to. It can also include legal support, PR support. They can bring it to the attention of UN rapporteurs. They will actually, even in the gravest cases, arrange for you to get asylum in another country for human rights defenders. This organization was an offshoot of Amnesty International when they saw so many human rights defenders around the globe being persecuted for peaceful advocacy. And I need to underline that. Frontline Defenders will not be there if you are engaged in violence in the names of human rights. You have to be a peaceful human rights defender. So this is a great organization, and I would like to see organizations such as yourselves get in touch with these folks and replicate in a domestic way those kinds of supports for whistleblowers. I also think that public servants and others need a lot more training on moral courage, like Dr. Bryce had, and the consequences when you just sit back and think, well, I don't want to get into trouble. I'm not going to say anything, even if you know what is wrong. The consequences for people not keeping their eyes on Dr. Bryce and not enough people standing with them was, quite frankly, kids literally died. The consequence of the public paying attention to the Canadian Human Rights Tribunal case, but that the attention waning is even in the non-compliance proceedings. There's a legal order where Canada admits its non-compliance is linked to the deaths of 3 kids. So it's not that the stakes aren't high when people look away or say, I don't want to get into trouble, so I'm not going to get involved. I also believe strongly in encoding the UN Declaration on Human Rights Defenders into Canadian law. We have some of the weakest whistleblower protections in the world, in the developed world. This is, I think, an essential piece, and I'd like to see the BC government adopt legislation in that regard. Another key thing that I learned in my experience is, although I was ultimately successful in getting a finding by the privacy officer and by the tribunal that this was unlawful on Canada's behalf, there was no injunctive relief. There was no way to make them stop while you waited for the hearings to go on. And that's very, very important, because this can be very, very scary. And I think that there needs to be injunctive relief, just like you would have, for example, in a stalking case, in a domestic violence situation. There has to be something to stop these particularly powerful actors like governments, corporations, or powerful individuals from doing this type of behavior. I'd like to see social media regulations updated. I think tactical tech would be very helpful about how do you draw this balance of free speech, but also protecting human rights defenders and not weaponizing social media against democratic values. And as I say, strengthen the support network for human rights defenders. That really needs to be done. Your office, as an independent arm of government, is well positioned to do that. But I think that you could reach out to Frontline Defenders or other people like me who have had those experiences. So I just want to check my time. Excuse me. So when we go back to the case, had I been scared off when they did that retaliation for me, it's possible, but maybe not as likely that the case would have continued for the years it needed to in order to get the finding on Jordan's principle. There are many, many families now in British Columbia who are getting help under Jordan's principle for basic things like wheelchairs, healthcare, education supports, mental health supports, etc. These services would not have been provided had I not received the type of support I needed to get through that moment. And these are just some of the things like autism supports, all kinds of stuff for kids. The whole case is documented on film. Actually, you can even watch the retaliation hearings on film. It was taped cover to cover. You can learn more about this case and about Dr. Bryce even, and hear John Malloy testify, hear Dr. Robert Joseph testify. In the documentary by the National Film Board, We Can't Make the Same Mistake Twice. And you'll hear about the retaliation in that documentary as well. And then there's another free documentary you can watch, which is Jordan River Anderson, The Messenger. And that's an important documentary on how Jordan, like how the children were experiencing Canada's retaliation. By Canada saying no to these families, kids were literally dying in the hospital without any help, just because of who they were. And Jordan River Anderson is the founder of Jordan's Principle. It tells that story. We've converted the whole tribunal hearing into an animated special, because one of the things that we learned is children can see unfairness in clearer terms than adults can in Canada when it comes to Indigenous peoples. The kids didn't rationalize this inequality in federal services. They just saw, you mean some kids get less just because they're First Nations? That's not right. And they populated the hearing room. And they would amplify it by bringing other people, their parents, their grandparents, and others into that hearing room. So this animation tells a true story, is based on a true story of how those kids actually became human rights defenders in that moment. And I want to underline this for a couple of reasons. One is that there's not a lot of attention for children as whistleblowers. But the UN had a day of discussion on protecting child human rights defenders. And in anything that you're doing, I think that that's really essential that you do that. We've seen, for example, First Nations youth like Shannon Kustachin, who is from Attawapiskat First Nation, where her school sat on a toxic waste dump, literally 30,000 gallons of diesel fuel in the ground. She created an advocacy campaign called the Attawapiskat School Campaign, asking other school children to write letters to the government of Canada to get them a new school. She came down to meet with ministers, etc. But they, in their own way, retaliated against her because they felt that she was trying to make them, quote, look bad by doing all this stuff. Like, they weren't focused on the fact that here we have a very bright kid who just wants to go to school, but not on a toxic waste dump. They were looking at it as, oh, this is making us look bad. Make it go away, that kind of stuff. So pay attention to children as whistleblowers and human rights defenders. So when we last left Dr. Bryce, he was buried in Beechwood Cemetery. And Duncan Campbell Scott was getting all the glory, even though he was amongst the worst wrongdoers in the whole residential school thing. I actually stood in front of that gravestone the day before Prime Minister Harper made the apology for residential schools. I had learned about Dr. Bryce in John Malloy's book, A National Crime. I knew that there had to be people back then that would have stood up for those kids, who cared enough to speak up and do the right thing. And when I realized he was buried in Beechwood Cemetery, I got a bouquet of brightly colored flowers from the Byward Market, and I went over to visit him. Back then, none of that garden around his headstone existed. It was a very lonely grave. Only his family would go see him. And I told him about the case that was filed exactly 100 years after his 1907 report. I thanked him for everything that he did. And I told him I would be back when the kids won. So when the final decision for the tribunal, well, should have been the final decision, substantiating the discrimination against First Nations kids on the basis of race, was released in 2016. I went out in the middle of January down this large slope to see Dr. Bryce, and I read him the decision in the graveyard. Over those many years between 2008 and 2016, I started to see historical plaques propping up at different grave sites of other people that were buried in the cemetery. And I thought Dr. Bryce needs one of those too. So now Dr. Bryce's grave not only has a historical plaque, but all of the research that went into that plaque was made into school curriculum and is being taught to children across the country. Dr. Bryce's grave is now the most visited grave in Beechwood Cemetery. And a lot of the things that are left there are actually done by children or young people. So if you look closely at the slide, you're going to see a t-shirt, Every Child Matters. That was done by high school students who had actually got on a bus and came to Beechwood Cemetery. And they made that for him, and on the back are all their initials. And they left him a poem. We often find letters and everything else there. In fact, he gets so much stuff that we now have in a mailbox where people can leave things in there, letters to him, etc. He's not the only one buried there, though. Just over the hill is Duncan Campbell Scott. And he already had a historical plaque, and I bet you can guess it was pretty glowing. You know, Confederate poet, recipient of honors, blah, blah, blah. So we took the original research. We got together with Marie Wilson from the TRC, one of the commissioners, and John Malloy, the historian. We took the original research over to Beechwood, and we said, Duncan Campbell Scott's plaque needs a revision. And so now his plaque says, Confederate poet, and cultural genocide on the same plaque. And one of the key things that I've learned about this learning about history is that not all of your legacies are equal. You know, there's this false equivalency happens that, like with, for example, with John A. Macdonald, oh, he brought the country together. So, you know, the residential school stuff, yeah, that was bad. But, you know, when it comes to Duncan Campbell Scott, he is a Confederate poet. That does need to be recognized. But the weight of it, the effect of his poetry on society is far less than the weight of the impact of his command of residential schools and his allowing those children to die in those graves and many others to be hurt. So when we tell the story of history, we have to give weight to our various legacies. And that's why cultural genocide on his particular plaque is so important. That too has all been taken into school curriculum so that people can learn from these two people, two white guys in the same time period, confronted with the same challenge, which was children were dying. Bryce had the moral courage to be a whistleblower based on the evidence as a doctor and public health official. He was persecuted and forgotten for that. Duncan Campbell Scott was a bureaucrat and quite frankly, a coward. And he was rewarded for that kind of behavior. Not only by the bureaucracy, but even by others in society, despite the gleaming headlines of the tragedy of his particular work. I think our goal in 2021 needs to make sure when we hear about a Dr. Bryce, that we all run towards them and surround them. And we don't leave them until the work actually gets done. That was Dr. Bryce's greatest lament, his family says, is that his work did not get done. He died feeling like he was a failure. That's how he felt. He was a doctor. He knew how to save those kids' lives, and he did everything in his power to do it, but he wasn't successful, so he felt he failed. We can't have human rights defenders and whistleblowers feeling like they failed. He didn't fail. We failed him. And we fail him every time that we allow the government to get away with the ongoing inequalities. We fail him whenever we do not protect and safeguard credible human rights defenders in our own society. And we fail him when we exalt the wrongdoers. And we fail him by our own inaction. So what do we need to do? We need to denormalize discrimination. You know, we have an Indian Act. Just think about that for a minute. Indian Act, the same act that Duncan Campbell Scott used to force those kids into the schools and where they died, is still on the books today. It decides whether I'm a status Indian or non-status Indian. Like, this isn't a little bit of racism. This is a lot of racism, right? Even with the Wet'suwet'en, you see the RCMP going in there with all kinds of armament. But then we see anti-vaxxers not even being really challenged who are surrounding children's vaccine clinics. The Wet'suwet'en protesters are armed with marshmallows, right? This is the kind of stuff that normalizes that discrimination. We need to implement solutions. Had we implemented that 15,000 back in the days of Bryce, we would not be footing the bill for the billions and billions of dollars now needed to compensate the many, many thousands of people who were harmed and died, or to fix the system now. Same with murdered, missing Indigenous women and girls. That's really just sitting there in status quo. No one's really seriously acting on that in any major way other than community groups. We need to promote and protect human rights defenders. And we need to learn from the past injustices and also from the past superheroes. You know, the one thing that I hear a lot from people when they talk about, oh my God, you guys are trying to rewrite history. I always say, no, we're trying to really actually tell the accurate telling of history. And in that accurate telling of history, we're actually going to surface non-Indigenous people who actually did the right thing, like Dr. Bryce. That's what we're doing. We're also surfacing the many First Nations, Métis, and Inuit people who did the right thing at the right moment. So when we learn from history, we actually shift our adulation from those who have been kind of put up on a pedestal falsely to the people who really had the moral courage to do what was in the best interest of society. And that's the kind of people that I want kids in my family to look up to. I'd rather have my kid grow up to be Dr. Bryce than Duncan Campbell Scott, right? So here are some of the resources on this. I don't want to spend a lot of time talking about my retaliation. I just showed it because it pulls that same pattern into the contemporary field. And it shows how it's still happening to human rights defenders here in Canada and why your work is so important. So I hope that was helpful. And I'm happy to take any questions.
Thank you very much, Dr. Blackstock. That was a wonderful, wonderful presentation. I know I learned a great deal, and we'll be definitely checking those resources out and the documentaries. So thank you. Very relevant to our conference today, of course, and how things can go so terribly wrong when whistleblowers are ignored. So thank you. Thank you for your courage and advocacy on behalf of children. I really liked your message about paying attention to what children are saying, because they often report things exactly as they are. I think that's a really important message. Yeah. A couple of questions have come in. So, and a reminder, if anyone would like to ask any questions, they can put them in the chat directed to me, and I'll try and get to as many as I can. So one of the questions was, do you think a whistleblower protection law would have made any difference for Dr. Bryce in his attempts to bring his concerns forward at the time? Would public interest disclosure legislation have made a difference in this case?
I think that anything would have made a difference. Having more recourse, having different watchdogs to be able to kind of really force the government into acting, or at least disclosing more about what it's doing, would have been really helpful. I also would really recommend that in addition to that, you look at the work of like the journalists. I'm blanking right now, but there's a national and international organization of journalists who often get persecuted for telling stories such as on drug cartels, on corrupt government, etc. Journalists for Human Rights, that's it. So it's that partnership between not only the integration of legislation, but having that media, that human rights media, make sure that story doesn't drop off the front pages until it's solved. It's that kind of partnership, that holistic kind of partnership that's really needed. And then supports for that human rights defender. I'm sure, like, Dr. Bryce was a sophisticated man. He was, a very well-educated physician. He was spent his life in public service. Had he known that there was something there that could have protected him and allowed him to continue to do his work, so the work did get done, I have no doubt he would have used it. He tried everything. He wrote to Laurier. He did whatever he could to try and do it. So I'm sure he would have used it.
Yeah.
It would have made a difference for me, I'll tell you that.
Point that it was above the fold, as you say, only for a short time, and then the public lost it. Yeah.
But it keeps on coming up. If you read John Molloy's book, and I put the title in the book, I really recommend people get it, is you're going to find that these stories it wasn't just then. There were people of all stripes coming forward with concerns. And the reaction from Canada was the same. Wait for the story to die, or just cherry pick a few of the recommendations, implement those, and think that the public's satisfied.
Thank you for that. Do you have time for one more question?
Sure.
We close up. We've got a question, curious to know if anyone was held accountable after you learned and brought to light the unlawful surveillance. Your thoughts on the importance of accountability in the PIDA scheme. So any comments?
All the people that were most directly involved actually got promoted. And when we look at the kids, for example, Canada chose not to implement Jordan's principle. And during the time we were litigating, and a few families did come to their attention. And they were horrendous cases, like a 4-year-old little girl in palliative care who was denied equipment so that she could go home without suffocating. This is in the Christmas season of 2011. And the government of Canada has this award system for public servants. And Michael Wernick, who was then a deputy minister, he was also the deputy minister in the retaliation. So it's very interesting, his new book about saying he doesn't want records shared with everybody. I thought, yeah, well, you know what? That was very helpful to those of us who were actually trying to do the right thing back then, but that's a backstory. But he gave the public servants who made sure there were no Jordan's Principle cases the highest public service award that year. And in the award nomination document, he expressly says how he's being critiqued, the government's being critiqued by professional associations like the Canadian Medical Association, by provinces and territories, and that families and the Caring Society and AFN are litigating against them. But these courageous public servants have withstood it all, and for that they deserve the highest public award. So it was like that Duncan Campbell Scott reaction within the government was still alive and well. So no, they didn't punish anybody. And I do think there should be consequences for these people who engage in this kind of behavior. But I have to say that I think this type of behavior came from the very top of government. They were awarding that kind of egregious behavior. So it doesn't surprise me that these people, and in some cases, they've gone from the Child and Family Service file, where they were found to be racially discriminating against kids, onto other things like murdered, missing Indigenous women. The same people. It's like shuffling deck chairs on the Titanic.
Thank you. Thank you for that. And for reminding us of why this matters, why we're here today, why public interest disclosure legislation matters, and the importance of it, and that was really fascinating, and I really appreciate your time with us this morning. So on behalf of all of us here this morning, thank you, and for you and your important work that you're continuing to do. So thank you.